Danny, are you reaching out to your client to see if you can help him with his sound issues?
Yes.
Mr. Redkey, can you hear us? No, he went to mute.
I'm asking him to turn up his speakers. Did you get that, David? Okay, cool.
Okay, good. All right, stand by. Judge is jumping on shortly.
All right.
We are good.
All righty. Good morning, everyone. This is Judge LeMaire calling PB 2009-002224 in the matter of the conservatorship of David Wayne Redkey. Mr. Redkey, I do want to advise you, you had a live mic, so you could not hear us, but we could hear your conversation. We'll start with announcements, and I'm going to go around my virtual courtroom, starting with Ms. McCollum.
Good morning, Your Honor. I'm here and I'm represented by Jerome Elwell, who's also here.
All right, thank you so much. Ms. Warner?
Good morning, Katie Warner, I'm not, representing the conservator, Agatha Redkey.
All right, thank you so much. Mr. Elwell?
Good morning, Your Honor. As Ms. McCollum indicated, I represent Stephanie McCollum in her former capacity as conservator.
All right, thank you. Mr. Theut?
Your Honor, Mark Theut, guardian ad litem for David Redkey.
All right, Mr. Redkey? All right, thank you. Mr. Mazza?
Good morning, Your Honor. Danny Mazza. I am court-appointed counsel for Mr. Redkey.
Thank you, Mr. Mazza. And the 480307 number, who is that?
This is Agatha Redkey, current conservator for David Redkey.
Thank you so much for calling in, ma'am. So when last we met, we had proposed a February 19th hearing date. I tried to negotiate a timeline and was floundering, so Mr. Elwell generously suggested that counsel could work on that offline. Who would like to give me an update as to where we are now in terms of being ready for trial and moving forward?
Your Honor, we have circulated a scheduling order to counsel. There's no way, we don't believe we'll be ready for trial depending upon whether expert witnesses are going to be used or not. We have, however, circulated a scheduling order that we can submit to the court, hopefully by the end of this week. I would advise the court that on Saturday last week, Mr. Redkey filed a petition for special action pro se with the Arizona Court of Appeals. On Monday, the Arizona Court of Appeals denied to accept jurisdiction. And the same day, Mr. Redkey filed a notice to the Arizona Supreme Court. I've had conversation with counsel about whether or not the petition for special action and now the petition for review to the Arizona Supreme Court would deny this court of jurisdiction on the issue of whether Ms. McCollum's fees, whether her accounting should be approved and the fees and costs therein approved by the court. I believe it is the general understanding, but I will not speak for everyone, that the court retained jurisdiction over the question of the accountings for Ms. McCollum because the questions that are raised by Mr. Redkey on appeal do not impact that issue. So,
Mr. Redkey, you've not been called upon. Continue, Mr. Elwell.
So, Your Honor, in summary, the question is, I guess the first question needs to be asked and answered is whether or not the court retains jurisdiction despite the notices that were filed by Mr. Redkey. And if so, we can have a if the court retained jurisdiction, we will be prepared to submit a scheduling order, I believe, by the end of this week.
All right. Mr. Theut?
Your Honor, I don't disagree with anything that Mr. Elwell said. And I just wanted to bring something else up to the court's attention. Your Honor, in your minute entry dated August 21st, 2025, when you set this, we were going to address today the issue regarding whether the motion to dismiss would be granted. I've had a telephone conference with Mr. Mazza and Katie Warner. They, I don't have an objection, Your Honor, to continue the status conference on that issue for 30 days to give them an opportunity to file a response to the motion to dismiss if the court doesn't have any objections.
Mr. Redkey, please stop. Your behavior is not appropriate. Ms. Warner?
Thank you. I do. I had the conversation with Mr. Elwell. I don't believe that the documents filed by Mr. Redkey pertain to the court's approval of the accountings and the fiduciary fees that have been incurred. There has been no final ruling on those issues, so I don't think that's ripe for appeal, but we'll continue based on what the court instructs. And I did receive the circulated joint scheduling order to review with my client if the court instructs us to continue moving forward with that. And I did participate in conversations with Mr. Theut and Mr. Mazza. There was some confusion about the filing of the motion to dismiss under seal and the timeline of that. And so we all discussed the 30 days so that Mr. Mazza could file a response to the motion to dismiss. And I'm in agreement with that as well.
Okay. And last but not least, Mr. Mazza?
I agree with Mr. Elwell, Ms. Warner. If the court wants us to proceed, if the court's going to retain jurisdiction of the issues, we have the draft deadlines that we went over with Jerome that he graciously sent over today that I'll go over with David, and hopefully we can get lodged with the court by the end of the week.
Okay, fair enough. And so in my conversations with the Court of Appeals, haven't talked to the Supreme Court yet, because we're trying to track, because this is obviously a case that they're well familiar with, given the number of filings. I do believe I have jurisdiction in reviewing the file with regard to the accountings and the fiduciary fees, and we do need to get those resolved candidly in order to, if at some point this should be reviewed by the Court of Appeals and the Supreme Court, that they have a global picture of what to review. So with regard to the motion to dismiss, counsel, if you need 30 days to file that response, that's fine by me, and then we can do a reply. And if needed, I can set up for oral argument after the holidays. And then if we can get that joint scheduling order out, I'll vacate the February trial date if that's not realistic, and I can have my judicial assistant send counsel emails with regard to potential dates once we get the joint scheduling order.
Thank you, Your Honor.
And Mr. Redkey, as I've indicated to you a number of times, you are represented by counsel in this matter. You need to stop addressing my staff. You are represented. Your counsel will contact my staff if needed. But there are just concerns with making sure that we maintain conversations, especially when there is conversations back and forth between parties, that the division should not be party to. So just please be very mindful of that. At this point, I won't set any future hearings because I don't have the joint scheduling order yet, and we don't have the fully briefed motion to dismiss. So we can address future hearings at that point, if that works for everyone. Mr. Elwell, is that fine with you?
Thank you, Your Honor. That works.
Mr. Theut?
That's excellent, Your Honor. Thank you.
All right, Ms. Warner?
Yes, that's great. Thank you.
All right, thank you, Mr. Mazza.
Yes, Your Honor. Thank you so much.
All right, thank you so much, everyone. With that, we are adjourned. Thank you so much. The court will be disconnecting.
Thank you.
Your Honor.